Good morning and hello everyone. As IT Law Institute core team, we would like to welcome you and thank you so much for your presence here. Thank you for everything, for our speakers and moderators and participants. We prepared a lovely and funny symposium for you. My colleagues will give other details. And we just want to say hello as IT Law team.
You are more than welcome.
We are very happy that you're all here. We worked quite hard for today. And sorry.
Well, this is actually our 15th year. Quite much the same people that we had 15 years ago. There are newcomers, of course, that's great. But I think the most remarkable part is that now the director of the institute is a former student of the institute, and I think this is very remarkable, especially in Turkey, but also anywhere else.
And just a last word. This is not a data protection and privacy conference. This is rather it is the conference about the human values which underpins data protection and privacy. It's a wonderful quote from the opening speech of the 2018 ICDPPC conference, and the quote belongs to our dear friend Giovanni Buttarelli. And he was a good friend of all of us, or most of us at least, and we missed him really so much. He was a good thought leader, and he was a really humanist, and he taught us a lot of things in terms of privacy, data protection, and currently ethics.
Well, I'm also super excited to have you all here, and what I'm going to do is to just walk you through what we have today. Welcome again. As you might know already, this is the second Istanbul Privacy Symposium organized with the collaboration of a network of centers. And we are, again, so excited to have you here. So what I'm going to do is to kind of give the technicalities of where we are and what are we doing. At first, if you have not realized already, I want you to take a look around where you are, realize that this is a command room. And this is the Energy Museum of Ottoman Empire. It's just in history right now. So we are in a historical room. And I think this is really important because what we're going to do here is to talk about future. So in a historical place, we're going to shape the future. How cool is that? And as Leila Kesar, my professor, dear professor, told that this is not just a privacy conference, this is about human values. This is something we really care about, and we wanted to explore new ideas by having an imagination corner. When you were at the registration desk, you received these flyers, which kind of explains what we expect from you. This is basically an art project that you are going to create. It's going to be really fun, and what we basically ask from you to do is just pick whatever you like from the table. There are Play-Dohs, there are sparkles, whatever you like. It's a very cute table, and we want you to walk through the questions here. They're kind of long, so I'm not going to go here. But it is basically just to create this another medium to think about these hard concepts and kind of collaborate in a way that we think out of the box. So we're really excited to have that. And you can just drop your artwork by 6 p.m. Apart from that, we will have coffee breaks right there, as you can see. And if you need to use the bathroom, it's that corner. You need to take the elevator to the entrance, and it will be on your right side, I guess. And finally, we will have 4 sessions. We're going to start with an opening speech, and then we're going to kick off with the session 1. And now we're going to have the keynote speech because our keynote speaker's flight has delayed. She's on her way, and she's fine. And then our first session will be data-driven technologies and regulation. The second is law, ethics, and AI. And the third one is a keynote speech. And well, technically it's a keynote speech itself, but the session 3 is new dimensions concerning privacy and data protection. And finally, we're gonna have human rights, ethics, and technology. And without further ado, I would like to invite the director of Istanbul University's IT Law Institute, Mehmet Bidikaya, and director of ITS Rio, Carlos Afonso Pereira Souza, to deliver their opening speech.
With your permission. And good morning, ladies and gentlemen, and dear friends, of course. I'm very pleased to be at the opening of this second privacy symposium on law, ethics, and technology. So nice to see you again this year. Last year, we have started scrutinizing a very hot topic, and we have started looking to the correlation between law, technology, and ethics. This year, we are taking this last year's work further, and we hope that in the following years, we keep working on this area. We are truly delighted to welcome you here today. I can see too many colleagues, academics, lawyers, engineers, students, all of them in one room. You are all welcome. I'm Bedikaya. I'm currently assistant professor of IT law here at Istanbul University Faculty of Law. This year, I took over the flag from my dear professor Leyla Hoca, and I'm the very new acting director of IT Law Institute. I also would like to take this occasion to thank Leyla Hoca for her trust and support. It's a very special privilege to welcome you on behalf of my institution. As Elif mentioned, before disclosing the symposium, I would like to have a few words about the place. Some people have likened it to Chernobyl's room, control room. Indeed, as Elif mentioned, it's a historical place. This was the Ottoman Empire's very first urban scale power plant, and this facility provided electricity to the city from 1911 to until 1983. So a very long time it was a center for distribution of a very important utility, electricity. We also hope you find our campus and Istanbul interesting and charming as we do. You are more than welcome. Indeed, it has been another challenging year for privacy. We are passing through challenging times. Law is evolving, technology is evolving, and ethics is being redefined in accordance with this evolution. There are very new regulations, rules, principles, case law all around the world, reshaping the way we interpret law, technology, and ethics. Just a few days ago, Kenya had their very first data protection law. This is also an example of how data protection and privacy regulations all around the world are getting disseminated. Indeed, the concept of privacy is a dynamic concept, and the continuous evolution of the world requires a dynamic interpretation. We are trying to look from this particular perspective. As Leyla Hoca mentioned, this isn't a classical data protection conference event. Rather, it's a conference that looks through the human rights perspective, the human values that underpin privacy. Our main goal for this event is to reflect the multidisciplinary nature of privacy and the surrounding topics. Since we think that privacy is related to law as much as it is related to ethics. Privacy is related to engineering as much as it is related to public policy. So they are all connected. Your presence and contribution to discussions means a lot for the success of this symposium, so please do contribute. I would like to extend a special warm welcome to our distinguished speakers and guests, many of whom have traveled far away to be with us today. Also, our sincere thanks go to our speakers, guests, our technical team all around the room, and some of them are behind the scenes, our organization committee, our sponsors, everyone who have made this event possible. We are truly delighted to welcome you here. Again, good morning and welcome. I would like to give the floor to my dear colleague Carlos from ITC Rio. He will also provide a short insight with regard to network of centers, the affiliation that our institution is also a member of. And again, thank you. You are more than welcome. It's our extreme pleasure and honor to be with you. Thank you.
So, hi everyone, good morning. Thanks, Betty. It's really a pleasure to be here with you this morning. And let me just begin saying thanks to Betty, to Leila, to Ilif, and to all of friends from IT Law Institute. This is such a great event and such a great opportunity for us to bring together different experts from different regions of the world to discuss privacy and data protection, and especially how technology end up coming into an interplay that is really, really interesting and fascinating concerning how social norms, economic aspects, technical architecture, and policy and regulation comes into play when we come to discuss here the future of privacy and data protection with this human-centric approach that it's something that we have been learning from a while from the life, from the work, from the legacy of Buttarelli. So it's really an important event that we have ahead of us today, and I can say I couldn't be more happy to be here with you this day. So a very, very short introduction. The IT Law Institute is part of the network of centers. It's the Internet and Society centers for the Internet Society, Global Network for Internet Society centers. And the network was created back in 2011 with the idea to connect different centers that have been working on interdisciplinary work concerning different aspects of law, technology, economics, and social studies, in order to make sure that this conversation is not separated into different bubbles, different regions, and that we try to connect what is different and what is similar from the different regions of the world. And to be quite frank, one thing that we definitely need today is to connect the dots on what different regions are doing concerning privacy and data protection. Of course, Europe ended up sending a lot of inspiration with the approval of GDPR, but it's important for us to understand how GDPR is being implemented, what are the restrictions, what are the challenges ahead, and how those challenges might be important for us to learn some lessons and to make sure that different countries, when they approach issues concerning privacy and data protection, that they can do it on the best way possible. So this is just to say that the network right now has more than 100 research centers spread out through the world, and I'm quite happy to be someone who comes from Latin America, from Brazil, and the institute that I'm coordinating, the ITS Rio, the Institute for Technology Society in Rio de Janeiro, right now is spearheading the secretariat of this network. And our idea is to make sure that the network provides a place for different centers, for different people to gather around and to discuss in an interdisciplinary way the topics that we are going to address today. But without further longest, I think we switch to our first panel. Do you want to? Oh, okay. All right then. So let me just give the floor back to Elif. All right, so thank you all.
Yay! We have our keynote speaker here. So without further ado, I'd like to invite her, Judith Ruhofer, to deliver her keynote speech on Beyond Consent, using the fairness principle as a means to facilitate data subjects' control and autonomy in the digital age. Welcome.
Can I see my slides? Sorry, because I am...
They will be starting right now.
They will be... brilliant. That's good. Yes, okay. Right, okay, when my slides load, I usually, I usually apologize anyway. Today I have to doubly apologize. I have never in my life overslept for a keynote. Today is the first, but I don't know what happened. But here I am. Okay, so my first apology is that I'm late. My second apology is that I have about 15 more slides than I have time for. So I may have to run through some of them, but I hope that's going to be okay. Thank you very much to the IT Law Center for inviting me. That's very, very lovely from your view. And I hope that what I have to say about my musings about consent is going to be interesting for you. This is an article, or this talk is based on an article that is some 8 years in the making. I think it is something that I've been percolating over for years and years, and the actual article is actually going to be co-authored by one of my former PhD students, which is hopefully something that my future PhD student who's in the audience is happy to hear, because I do that. Basically a lot of the thoughts in this article come from him taking my weird ideas and just running with them and actually writing them down, and that's great, and that really helped me. So let's start with no further ado. So I wanted to start with this quote, which is actually from a report that the OECD had commissioned and that was published in 2011. And it basically very concisely says something that many of us have been feeling for a while, and that is basically, sorry, I just have to move over here because I can't read my own screen. It says the individual is an active player in personal data flows, particularly now in the context of social media. And technology and business models are presenting new kinds of uses of personal data. Privacy principles have given way to the importance of individual control in privacy protection, but questions can be asked about whether such emphasis is providing the best protection. And I think that's probably where we all are these days. We all do like the idea of having control of our data, and it is something of a truism that this control is what data protection law is all about. But at the same time, we know that our control and that the consent that we give at this moment is largely abused, and that we do not actually have all that much, how shall we put this, control actually over what we consent and what we don't consent to. So when we talk about what we now call information privacy, the general idea is that we talk about individual control. And when we look at the definitions of information privacy that we have had in the early years of sort of privacy and data protection, you will see that they all center on this idea of control. There is, of course, the Western definition, which many of you may be familiar with, which is the claim of individuals to decide for themselves, who has, how, when, and to what extent information about them is communicated to others. Then there is a less well-known definition by Fried that makes the same point. And me being German, originally I am in this weird position where I was trained as a lawyer in Germany, so I have all the cultural German hang-ups about privacy. And then I spent my adult life in the least privacy protective country in Europe, namely the UK. So I am this wonderful combination of the two extremes in Europe with regard to privacy. But my heart belongs to the German Constitutional Court and always will. So this is the definition that the Constitutional Court used in its famous census decision, where it created the right to informational self-determination. So as you can see, all of these definitions somehow center around individual control. So is this what we're talking about when we're talking about privacy or data protection? Well, I'm not sure, because what I did this time around, and I very rarely do this, but sometimes I become nerdy and geeky and I actually just, look at the text. And I looked at the early texts of all the international instruments that we use as our our data protection Bibles, our roots, our origins. So that is the Convention 108 from 1980. It is the OECD Privacy Guidelines, no, 81, the OECD Privacy Guidelines from 1980. And it is sort of the first proposal from 1990 that in which the European Commission proposed what ultimately became the 1995 Data Protection Directive. And I was really surprised because actually the word control in these documents doesn't come up at all, at least not with regard to the individual. Where it is used is with regard to the actual data user, and who is then, as we now all know, ironically defined as the controller. So is data protection actually all about individual control, or is it actually about something completely different? So what we have actually seen here is that data protection probably is what happens when the individual has already released their control. Because really, if you think about what data protection law does, whether this is the 95 direction or whether it is now the GDPR, it governs all the things that happen either when the individual has no control, so if the data is processed on the basis of another legal ground rather than consent, or what happens if the data subject has indeed exercised their control and relinquished it thereby by granting their consent. Because really data protection law is everything that the data controller is allowed to do. So, all of that, however, one could argue, has changed in the second generation data protection instruments. So as you probably all know, all of these three instruments have undergone a revision. The 1995 directive has turned into the beloved and much hated GDPR. The OECD Privacy Guidelines were revised in 2015, and the Convention 108 is now what we call Convention 108 Plus. And that comes from 2018. And all three instruments, well, two of them specifically, but the third one impliedly, have now a much greater focus on individual control. It is actually mentioned in there that, in the GDPR in particular, that natural persons should have control of their personal data. And similarly, Convention 108 Plus acknowledges the need to be secure the human dignity and protection of human rights and fundamental freedoms of every individual based on a person's right to control their data. Now, the OECD isn't quite as vocal as we would expect from a more market-orientated and less fundamental rights-orientated instruments, but even they have strengthened the individual tools for control, or the tools for individual control, shall I say. So there is a push now about this whole control thing. So what I did then is I looked at the GDPR specifically, and I was looking at, what are we actually given as individual data subjects to sort of exercise control. And we can basically distinguish between ex-ante tools, so the ones that we can exercise before the processing really gets going. And that, of course, the most important one of that is consent. So in a situation where none of the other legal grounds applies, our consent is the yay or nay kind of a legal ground. So if we don't give it, we control the fact that our data is not being processed. If we give it, we allow the data to be processed. But there are also a number of ex post tools, so the tools that we are basically exercising when the data is already out there. And arguably, because the data gets out there so easily, I mean, all of us just going on the internet, we generate data without wanting to, sometimes without knowing. So the ex post tools are very important, and these are largely the rights of the data subject, as they're now called in the GDPR. So the right to rectification, right to erasure, right to restriction of unlawful processing, data portability. And then there is the right to object, which can maybe be classified as both an ex ante and an ex post tool, because you can object both to the collection of data and to any subsequent data afterwards. So the question is, if individual control is this big thing in data protection law, why is that? And anyone who does not immediately hear in your brain, what is it good for? You are the wrong age for me, okay? Because this is basically what my generation would have as an immediate response. So individual control, what is it good for? That is the question I asked myself. And this is where this the next apology comes in. So this is where I become a little legal theory-y. I don't do this a lot, but I sometimes do. Okay, so the notion of control is my hypothesis. The notion of control is not an end in itself, it is a proxy. And it's a proxy not for this value of, or this right of privacy, but for the values that underpin privacy. So the next question we need to ask ourselves is really, when we talk about privacy and the right of each of us to control our own data, what do we actually seek to protect? And here, my beloved German Constitutional Court and my beloved census decision has been very helpful, but there are a few other ones as well. So basically, if you think about what we protect with the right to privacy, there are a number of different ways. So I've listed a few here. You might be able to come up with others. If so, please send me an email. This paper is a work in progress. So privacy protects, among other things, the individual's right to self-actualization and the development of their own personality. Okay, we need privacy to become the person that we are. I once gave a paper about Twilight. And basically, I don't know if any Twihards are in the audience, but basically, maybe you know that in Twilight, one of the vampires can read minds. And my mind exercise was, how would we feel if that actually was the case? And we would hate it, okay? And every single year when I make this point in my classes, one of my students pipes up and he says, oh, I wouldn't mind, I've got nothing to hide. And I was just like, you probably just thought, oh my God, she's boring. And would you really want me to know that, okay? But the most important idea here is that we need privacy for this process of self-actualization, of figuring out who we are, what we want in life, and so on and so on. We also need privacy to decide how we present ourselves to others, okay? So the person you are with your mother is a different person from the one that you are with your friends, your partner, your boss at work. You are different people, and privacy allows you to be different people. So this is another very important point that we're making. Individuals' right to both develop and communicate opinions and convictions also belong in this. So this is not so much the right to freedom of expression, so the idea of what to say, but even the point of getting these opinions, of gathering everything that we sense around us and coming up with our own position. Privacy is needed for that. And then finally, privacy is needed to make decisions based on these convictions and to act on them. And that is, for instance, the idea of being able to participate in demonstrations, the right to vote, whether or not who we vote for. So there is always privacy involved. So when we really look at it, what we find is that privacy, or information privacy in particular, reflects much more fundamental values that we protect in human rights law. And the values that I want to look at here specifically are dignity, liberty, and autonomy. And this is where I have to go a little bit faster because this is very long. So the assumption here is that without respect for these values of dignity, liberty, and autonomy, and without the right to exclude others from our spaces, from our thoughts, from our actions, we cannot express our own individuality to its fullest potential. We cannot participate in society as our own true self. So that is our working assumption. If we now look at the ideas behind those different values, is that dignity is something that Europe in particular is very keen on. It's the first article in the Charter of Fundamental Rights. It actually is also the first article of the German Constitution. It is the highest value. And the idea behind this is very Kantian, namely that we should treat each human as an individual and as a human and never as a commodity. And that, of course, is one of the problems that we're now facing with regard to big data, because big data commodifies us. It commodifies us as units, not for our own benefits, but for the benefits of the person who processes our data. Credit scoring is a really interesting case in point here. So credit scoring is ultimately, maybe helping me to get a loan, but what it really does is it helps the loan provider to not lend money to somebody who might default on it. So they know so much about me that they can pinpoint to a very, very close degree whether I am one of those people they want to lend money to or whether I'm one of those people they do not want to lend money to. And because that makes me a means to their end, one could argue that this is a violation of my dignity, okay? So privacy and my ability to not give them all that data that allows them to do that is actually one way of protecting my dignity. The next value is liberty. So liberty, and in this context also self-determination. Now liberty can mean a lot of things, and if you look again at the Charter of Fundamental Rights, there is an entire chapter called liberty, and there's all sorts of stuff in there, you know, freedom of the person, liberty of the person, the body. But what I'm talking about here is this liberty as the right to self-determination and informational self-determination in particular. And we talk about this in our area often in the context of surveillance and our right to be free from government interference, and that means specifically in our area generally be free from government surveillance. So this is, again, something that the German Constitutional Court has defined not just as an individual right, because it can have real repercussions for me, as we see currently with protesters in Hong Kong. So they have real issues around their personal safety and so on if they're recognized. But it also obviously has a communal, a public aspect of it. And the Constitutional Court has said this very nicely, because it's not just my own status that is at risk here. If I am too scared, because my right to privacy is interfered with, to then participate in democratic structures, then that has a knock-on effect for democracy and for society itself. So liberty, we protect liberty not just for the individual, we protect liberty in a liberal society to protect society itself. So there is a public interest in liberty in this context. The problem here then is, or the conclusions here then are that individual liberty does not exist in isolation, but that it actually is protected in the interest of the individual and in the interest of free society, but that also maybe to a certain extent imposes an obligation on us as individuals to exercise our liberty, not just in our own interest, but also in the common interest. And those of you who are still with me may now make the connection to consent, because when we are consenting, some of the things that we're consenting to ultimately potentially not just harm us, they might potentially harm others, and we're going to get to that. Right. So the GDPR knows all of this too. And the interesting thing, of course, is that when people talk about the GDPR, it's always often portrayed as this big thing that grants all the power to the individual, and the poor businesses have no rights anymore, and they have all these compliance burdens, and it's terrible, and we need to strike a balance. But actually, when you look at the specific definitions or the specific provisions in the GDPR, you will realize that it already does that. The GDPR really limits its control tools. So all the tools that I've listed before, they are all limited. Consent, as you know, is only one of several legal grounds. So it is perfectly possible to actually process personal data without the individual's consent. The right to rectification and erasure and the rights to restriction, they are all only applying in specific circumstances. The right to data portability only applies to certain types of data, and the right to object has to be balanced in most cases against the legitimate interest of the data controller. So it isn't as if we are granting unfettered absolute control to the individual already. So I'm saying this mostly because when I say that we need to further limit the individual's ability to authorize data processing by consent, what I often get back is, but personal autonomy. And that's then my next point. We actually do not have that much control as it is, but the personal autonomy argument is always thrown back at us still about any restrictions or limitations on consent. So let's talk about autonomy a little bit. What does autonomy mean? Well, the general definition of autonomy is often one of free will, of being the captain of your own ship, the master of your soul, all of this sort of stuff. But we all actually know that in reality our decisions are informed by existing power balances or better power imbalances. How much free will do we really have? I mean, how many of you have, within the last 24 hours, consented to a data processing that if you really had free will, you wouldn't have consented to? Show of arms. Yeah. I mean, I am about as privacy, that's actually a really low number, to be honest. Have you not been on the internet at all? I don't know, maybe you're really not bothered, but I mean, I am as privacy paranoid as they come. And I was at Istanbul airport last night, and I had ordered a shuttle just before I stepped on the plane, and they hadn't emailed back to me, and my phone wouldn't connect, and I needed internet. And in order to get internet at Istanbul airport, as some of you may know, you have to hand over an awful lot of data. And at that point in time, I did not care. I gave them everything. Still didn't get on the internet, but I did really not care, okay? So is that free will? Is this my autonomy? Not so much, I think we can argue. So when we really look at our autonomy, we have to admit, we have to acknowledge that our autonomy, our right to decide who knows what about us, is already restricted. We are under economic constraints because we have to hand over data to get a service. And that is not, you know, the Facebook services of this world, which are often laughed about, you know, why can't the kids live without Facebook or Twitter or Instagram or Snapchat or whatever it is. I'm so old, I don't know what's current and hip and everything. But, you know, I'm talking about benefits claimants who need to hand over data to the state in order to get benefits that they need to survive. I'm talking about these kinds of things. We have societal or social constraints. We will hand over data in order to keep relationships, social relationships going, okay? We will do that even though we don't know that and don't want to do that. And we have legal constraints. We also have constraints that I would call, I don't know, dire situations, okay? Somebody who these days needs a heart transplant, for instance, or not a heart transplant, somebody who these days needs a cochlear implant or needs a pacemaker. These pacemakers or these cochlear implants, they basically transmit personal data, sensitive personal data, all the time, because their functionality is monitored through this, okay? Now, would you really say no to a pacemaker that you need to survive just because that pacemaker emits personal data? You probably wouldn't. But you are also not really exercising autonomy in the widest possible sense. And the other thing, of course, is that where I exercise autonomy, I might infringe other people's rights. And this is, again, what I'm trying to explain to my students when they go out there and use all these wonderful functionalities. So my two bugbears at the moment are Fitbits, where history has just beautifully verified the point I've been making for a very long time. And the other one is DNA analysis, okay? So both of those you think, oh, it's a bit of fun. Why shouldn't I game my workout? Why shouldn't I try and find out, you know, what my heritage is genetically and all of this sort of stuff? But the problem is when you hand over this kind of data, you're not just putting yourself in a vulnerable position. You are actually contributing to a vast data pool that can subsequently be used by the people collecting that data to make decisions not just about you, but about other people. About people who share your genetic makeup, about people who want health insurance and who have maybe a similar fitness profile to you, and because, you know, you got ill and you handed all your data over with regard to this fitness profile, the insurance can now draw conclusions from that, and they can now say, okay, so people who don't go running 5 times a week and who eat that sort of food and who have that sort of lifestyle obviously are at higher risk of doing this. So we will no longer give health insurance to people who fit that profile. Okay, so the point I'm trying to make here is that you exercising your autonomy, even for mundane things, actually means that you potentially harm other people in the future. So your autonomy has to be balanced against other people's rights. So the question here is our free will just an illusion? Well, maybe not, but we possibly have to look at the wider picture, both with regard to the collective harms that I've just described, and of course the big discussion of our day, which is the societal harms. So we're all being tracked on the internet, okay? And when we started talking about this in 2010, there were some people in the room, I was one of them, in Brussels and the European Commission, and we looked at this and we realized that there was this massive opportunity to manipulate people, and we felt really about this, okay? But we couldn't really put our finger on why this was so dangerous. And the argument that was made to us was, but it's only about advertising. What's so bad about being sold a fridge when you want to have a fridge, okay? Do you not want to see targeted and, you know, advertising that is relevant to you rather than all the other stuff that you're not interested in? And it's a difficult argument to refute. But what Cambridge Analytica has shown us is that as individuals, we potentially cannot just be manipulated into the brand of fridge that we might want to buy. We can potentially be manipulated to vote for a particular person or a particular issue, like we do at the moment in the UK with Brexit. So there is a really big issue here. And the question therefore is, or the point therefore is, that maybe we're asking the wrong question. Maybe what we really should be asking is whether, like with liberty and autonomy, what we actually need, or the question here is all of that, is this absolute individual control actually desirable? And my argument would be it's not desirable, neither for us as individuals, nor for the collective, nor for society as a whole. And what we therefore need is to go beyond this idea of consent, okay? By the way, for those who get dizzy, I have these slides, and please send me an email afterwards if you actually want to read them properly, okay? So how do we go beyond consent? Now, and here is where this becomes a little bit unrealistic, okay? Because my idea of going beyond consent is the data protection principle. So going back to first principles, as I say in my case, the fairness principle. And a lot of people might say, well, that's been done before. And it's true, it has been done before when we talk about fairness, because fairness is a concept of multitudes, and it actually is something that is talked about a lot. The first area and where this is talked about at the moment is fairness as justice and equity and the absence of bias. And that is mostly the discussion right now in terms of machine learning, in terms of algorithmic decision making. And I'm not even going to go there, because that is an entire discipline that is developing, that has conferences and, you know, articles and stuff like that. And, you know, I won't touch that with a barge pole, because I feel I'm way behind the curve on this one. So this is where fairness is looked at in a very specific way. There is also a going back to fairness as an existing principle in consumer rights, in consumer protection law, and that is something that I've also, this is why this article is 7 years in the making. This is where I started also. But unfortunately, that article was written by a colleague of mine from the Netherlands, Natalie Helberger, with some colleagues, and she wrote a really fantastic article about how we could use consumer protection law to actually restrict individual consent in data-related contexts. And I'm going to say a little bit more about that in a minute. But I want to go beyond that, actually, and there are reasons for that. So basically, Natalie, and I think was it Frederick who, I think it was Frederick, yeah. The two of them, they wrote this wonderful article about using the fairness concept and the good faith concept in consumer protection. And basically, they argued in a very German way, because the German courts picked that up as well, as you will see. And that basically means that privacy policies ultimately are nothing other than business terms and conditions. Business terms and conditions have historically always been subject to judicial review by consumer protection law, meaning that a clause that is unfair under consumer protection law is not binding on the consumer. So this is the tool that consumer protection law uses. And Natalie and Frederick ultimately make the argument that if privacy policies are business terms, then we can just straight up apply consumer protection law to any data-related business terms, and we can say that any business terms that are unfair to the consumer are basically non-legally binding under consumer protection law. And that's a very, very tempting concept to make, and I think it still has a role, because it is one of the levers we can use. However, it also has a downside, and that is the nature of consumer protection law. Consumer protection law is very individual focused, okay? It basically applies to this one relationship between the consumer and this particular business. So any harms, any unfairness, any notions of unfairness it will take into account are specifically the unfairnesses that harm this particular consumer. And that, of course, leave out completely what I've just said before, the harm that we as individuals potentially cause others and society as a whole. Consumer protection law just does not have this fundamental rights focus that is wider than just the individual. It's therefore ill-suited to the protection of these wider rights and values, I think. So then we come to the unknown unknowns, to speak like Donald Rumsfeld, and that is the fairness principle that we actually have in data protection itself. So as you know, Article 5.1a says essentially personal data must be processed fairly. But as Damien Clifford and Jeff Ossos has already said, it's such a slippery concept. And really, we have done some research about how fairness is defined by the regulators, you know, what kind of interpretation is out there at the moment, and there is so very little. Some of it is our language barrier, so if there's anybody here who is aware of fairness guidance by their own regulators and who can translate this for me, that would be wonderful, and I would love you forever. For me, at this point in time, I had to look mostly at what the ICO said and what the legislation itself said. So the legislation itself is not actually that bad. As they say, we have the fairness principle and we have recital 42, which basically says that where controllers seek to obtain consent to data processing activities through pre-formulated written declaration, this declaration should not contain unfair terms. So this is the consumer protection tool in data protection law. And Article 7.2 then also says that where these unfair terms are then not legally binding on the individual. Okay, so that is essentially Natalie's and Jeff's, Natalie's and Frederick's argument. But I think we can go further. I think we can actually use the fairness principle as a limit on consent. And basically to say that consent cannot be used as a legal ground to justify processing that would otherwise be unfair. Now again, every time I say that, this seems so obvious to me. And I don't know whether actually everybody agrees without having to discuss this much. Because nobody has yet said that this is ultimately, that this is actually not true. But nobody has really said that it's true either. And I think this is where our current uncertainty and our problem lies. Now, the Article 29 Working Party, in its guidance when it was still it, has made it very clear that the data protection principles can act as a limit on the legal grounds. But it has not ever really spoken specifically about fairness. So what is fairness when it's at home, really? Now, the ICO has interpreted fairness as an obligation on controllers to only handle personal data in ways that people would reasonably expect. That's almost an American approach, reasonable expectation of privacy, and to not use it in ways that have unjustified adverse effects on them. Okay, so that's not a bad start, actually. So whether or not personal data is processed fairly depends on how it was obtained, they say, in particular whether or not the data subject was deceived or misled when it was obtained. Now this is why we have these long privacy policies that none of us reads, among other things, okay, that we actually get all the information. Whether that means that we weren't misled is another matter, because I don't know how long the Apple iPhone privacy policy is these days, but the last time I checked, somebody said it was longer than the US Constitution. So it is not something that any of us read on a daily basis, we know that. The problem is that there is no really clear guidance on what constitutes an unjustified adverse effect, even for the individual. And of course, there is no mention of these other harms that I've mentioned, the harms, the collective harms, the societal harms. And therein lies the problem of this current definition. Fairness is also mentioned in a way in some of the international approaches. So for instance, the African Union Convention on Cybersecurity Data Protection, which I can actually warmly recommend. I recently had occasion to look at this, and it's actually great. This basically defines fairness as when data was obtained fraudulently. The Asian counterpart, the APEC Privacy Framework, says process is unfair if the data was obtained on false pretenses. Now there are bits of beginnings of definitions, but so this is what I want to finish with, the definition that we're going to put forward. And basically it's this old wedding rhyme that we have in the UK, something old, something new, something borrowed, and something highly unrealistic. The first thing for me is how would we actually get this into current law, because as I tell my students at the moment, when a student writes an essay to me at the moment and they say, oh, we must amend the GDPR to do this, that and the other, I'm just like, oh, child, do you have any idea how long this took to get going in the first place and then to get through the legislative process? And we are all completely aware that nobody in their right mind is going to touch the GDPR with a barge pole for at least another 15 years. So even though legislative, change would be welcome and probably the best way to do this, this is where the highly unrealistic comes from, okay? This is not going to happen, we know that. But we've known this always, and there is another way, okay? So the last time we made changes, we had what I here call the guidance case law revised legislation pipeline. Anybody who's been around the block and who looks at the GDPR knows that what is in the GDPR now is what used to be in the Article 29 Working Party guidance before it, and with a bit of a stop at the EU court in the middle, okay? So I suppose this is the way we would have to go again. We would basically have to influence regulatory guidance, and then we would have to Schrems it, for those of you who know Max. So we would have to bring strategic legislation, a strategic case law, so to speak. But looking at, the definition of fairness. So I would go about this in two ways. I would first define what is considered fair processing, and then I would secondly define what is considered unfair processing, okay? So fair processing, personal data would be processed fairly, I would say, and this brings together the definitions we already have, if the processing meets the data subject's reasonable expectations and if the data are not obtained fraudulently through the deception of the data subject or under false pretenses, okay? And then we would have to think about what does this actually mean. So it would be, the reasonable expectations would be exceeded in specific circumstances. And for instance, sorry, I really can't read this myself, so these slides are terrible, I apologize for them. Yes, I may have to turn back on this one very briefly. So the data subject's reasonable expectations may be exceeded if a controller has collected the personal data for a very general purpose, but then uses them for another purpose that it hasn't actually informed the data subject about. Now you would argue that is a purpose limitation infraction, and I would agree with you, but it could also be considered an unfair use of the data, because sometimes there are ways and means to get around purpose limitation, and actually the likes of Google have beautifully managed to do that with combination of data and all sorts of things. So I think if we have a second lever in fairness, that would be a really good way of restricting that. Personal data would be obtained fraudulently or on false pretenses if the data subject is deceived for any of the following, okay? The identity of the data controller, the type of data that is collected, the purpose for which the data is processed, and whether the data is transferred to a place where there is no adequate protection. So far, so normal. None of this should be in any way, controversial. I think the new bit, the something new, would come in when we look at unfairness. How would we define unfair processing? So our suggestion would be that personal data that are not processed fairly if the processing causes unjustified detriment, not just to the fundamental rights and interests of the individual data subject, which is what we have at the moment, but the rights and interests of a group or category of individuals who share significant and protected characteristics, that's the collective harm argument, and to important objectives of general and public interest, that's the Cambridge Analytica situation, okay? So if we were to widen the fairness definition in that way, I think we have a way in which to limit consent that is specifically embedded already in data protection law. We don't have to go out to consumer protection law, we don't have to talk about fairness and algorithmic decision making. We have a very fundamental first principles approach. If a data controller wants to process data in an unfair way, then consumers or data subjects should not be able to consent to that. They should not be able to authorize that kind of processing through their consent. And that's really it. I'm just going to go through this. So my conclusions, you'll be glad to hear, and I don't know how much over time I've gone, but I've just been informed that this is Istanbul time, whatever that means. But a Turkish person said this to me, so I'm making full use of that. Although the notion of individual consent is embedded in EU data protection, that individual control is not absolute. And we know this already. Control acts as a proxy for values that underpin the right to privacy. And we therefore have to look at how do we protect those values best. We're not protecting control as an end, we're protecting controls as a means to protect those values. And if the exercise of control ultimately harms the exercise of those values, then we're doing something wrong, okay? We cannot fetishize individual control over the protection of the underlying values. So limits on consent as an expression of individual liberty and autonomy are therefore not just possible, they already exist in the GDPR. All of the control tools that the GDPR gives to the individuals are subject to existing limitations. So this is not a new idea. We are not barging in here and saying we are the first to actually restrict individual autonomy. What we're saying is we are finding a different way to limit individual autonomy, both in the interest of the individual themselves and the wider public and society as a whole. So the way in which we propose to do this is by reframing the fairness principle as a limit on consent and to really try to think about what does fairness mean. So what we need in the future is for specifically a regulator, the EDPB, a National Data Protection Commission or anything like that, to actually sit down and have a think about how do we define fairness. And it's not as if the EDPB and the Article 29 Working Party before it haven't done that before, okay? We have received a lot of law by the fiat of regulators. Whether you agree with that approach or not is, neither here nor there. The fact is it has happened. And to a certain extent, one could argue that this is the regulator's job, to really think about fundamental elements of the GDPR and to define or to make suggestions for what they should mean. And that's basically where we are at the moment. It's probably at the beginning of a longer period. I would not expect this to come to any sort of fruition, within the next 5 or 10 years, but it is a ball I want to sort of kick into the ballpark and ask people to start playing. So if anybody has any other suggestions of what fairness or unfairness could mean in data protection law, I'd be always happy to hear it. We've written about half the article, so there is lots and lots of room for changes and speculations and all of that sort of stuff. And thank you very much for listening to me.
So we're kind of late, but we're going to have 5 minutes for Q&A. We're not passing that. So if you guys have any questions.
Hi, thank you very much for this very interesting and provocative talk. I had a question. I saw you rush through it. How you actually concretize the notion of unjust detriment? I mean, that seems to lead to some of the problems we're trying to address.
Okay. Okay, yeah, I'm really sorry. The thing is, this is probably more a talk for an hour than half an hour, and I was clear about that when I finished the slides. Okay, so that's good. So let's just go to the very end. Yeah, there are a lot of slides. Yes, let me just try and get it off the top of my head. So I think the idea of unjustified detriment at the moment, the idea that this is part of unfairness is already out there, as I said. The UK ICO, the UK regulator, has already made that point, and I think other people are thinking about it in the same way. The problem that we have with this idea is that it's still a very individualized notion, okay? We're looking at it purely as detriment to the individual. As we know, detriment is powerful, okay? Detriment is what makes us do things and makes us not do things. So I think what we want to bring forward or put forward is the idea that detriment, how should I put this? Data protection law is not just protecting the individual, okay? Data protection law as a human right is fully in that catalogue of rights that protect society, that protect democratic structures, participation, and so on and so on. I think we are mostly agreed on that. That means that if we then have the individual provisions of data protection law, we have to define them in that way as well. We must not just define detriment as detriment to the individual data subject. We have to define it as detriment that can be caused by my actions to you. For instance, the DNA analysis thing that we might all suffer from ultimately from the conclusions that they draw from the inferences, and the harm that all of us contributing our online tracking data can cause to society, which is the situation we currently see with regard to political micro-targeting. There are probably many others, okay? We have absolutely no idea what's going to happen yet, and hopefully we're going to spend today on talking about some of those potential future harms. I saw some of the titles of the other papers today, and there is so much stuff out there. But detriment, I think our idea of unjustified detriment is just detriment that goes beyond harm just to the individual. Does that answer your question?
So thank you for this presentation. It was super interesting. So what I was wondering, at what point in the data processing process should this notion of unfairness be weighed and used? Is it an ex-ante tool or is it ex-post? I can see it would be used in a data protection assessment, or how do you view that?
Yes, I think here is where we actually do have to borrow from consumer protection law, and I think we have to look at the role of the regulator. The problem that we're having is, of course, that this is why it's, something borrowed, something highly unrealistic, okay? So we all know that the problem in the EU is not necessarily with the law, it's with enforcement. And the way in which we would have to police this is, of course, by really going hard after privacy policies that include consents for things that are very clearly potentially harmful. Okay, so if I were in an ideal world, I get all of this into the statute books, and now I give myself as a regulator the power to police that, to enforce that rule. What I would be doing is I would bring up the Facebook privacy policy, the Google privacy policy, the Amazon privacy policy, and I would go through this and I would look at it for any data-related clauses and data-related consents that would actually have potential long-term or immediate, cause immediate unjustified detriment. It's a complicated thing. This is why it's not ever going to run. So, this is why I'm saying this is an unrealistic proposal. I think what we need to think about is really, we have to be more ex ante about these things. We cannot continue with this approach where we just let them do it first and deal with the fallout later. And I think this is maybe an idea that has finally got, is having its time, because 5 or 10 years ago, when I talked about the precautionary principle at IT law conferences, all my tech law friends were basically like, oh, you can't do this, stifling innovation, this is so terrible. And I think, the risks that we are now facing are just so immense that people are finally starting to think, maybe we should head some of those off before they materialize. And that is, I think, the way in which we would have to do it. Review privacy policies and the consents that controllers, the processing authorities that controllers give themselves by obtaining consents that we all give without actually knowing that we're giving them in some cases, or that we give because we have no choice. Reviewing those against a general structure. And that is maybe my final argument about autonomy, okay? So a lot of people think autonomy is something that only I can exercise as myself, an individual. And I think what most protective laws are actually about is pooling individual autonomy in regulation. Because as individuals, we have no power against more powerful interests. But if we have regulation on our side, we are delegating our autonomy to the regulation, to the rule, to the legal rule, and the legal rule then helps us to work against the powerful interest that we alone would not be able to meet. Okay? I think 5 minutes are probably up, aren't they? Okay.
Can you just stay for a second?
We have a little present for you. Thank you very much for your speech. It was great. And also, we did a little thing for you from the art corner. Your speech reminded us of White Bird, freedom. Yeah. So yeah, this is a little present for you. Thank you.